A doctor who helped convict a man of shaking his baby to death is now being cross-examined on whether he even understood the scientific studies he cited in his own affidavit. The case involves Lindberg Garner, convicted in the 2026 death of his 2-month-old daughter Kalen, who is seeking post-conviction relief based on new scientific evidence challenging shaken baby syndrome. This hearing before Judge West will determine whether modern research on abusive head trauma justifies overturning that conviction.
Stand.
Not from the stand.
Not for much, Your Honor.
Okay, Dr. Lindberg, you can come on up. Do we need to wait a second?
No, she's just copying something. We can go ahead and start though.
How's she gonna come back in? She's gotta open that door.
Sure, that's fine.
That's fine.
It's not a jury. It's not.
Ah.
It's just us. All right, you can go
All right,
ahead.
thank you, Your Honor. Can I approach the?
Yes, sir.
Dr. Lindberg, let me start this morning by showing you this and see if you recognize that.
I do.
Okay, and this is
What number is that?
it defends exhibit number 12.
Thank you.
And this is an email you sent to Mr. Coleman, right?
Correct.
Okay. Let me show it to Mr. Your Honor, I'll offer.
It's admitted.
And can I stay up here and ask a question?
Sure.
Dr. Lindberg, you had previously, I guess, maybe last week, sent in an affidavit to Mr. Coleman regarding this case. Is that correct?
Yes.
And you inadvertently left, or somebody inadvertently left the footnotes off.
I'll cop to that.
Okay, so Mr. Coleman contacted you and asked you to send him the footnotes on this.
Correct.
Okay, and that's what this email is, where you sent him your footnotes to go with your. And let me ask you about footnote number 4. Footnote number 14 says Finney, J.W. Blumberg's PC Manavis J et al. Neuropathological changes in a lamb model of non-accidental head injury, the shaken baby syndrome.
Correct.
And that's the same article that we talked about yesterday when we started the discussion of the animal. And yesterday, if I understood your testimony, you said you weren't really you remember, you knew about that article, but you weren't really familiar with it.
I'm familiar with the article. I didn't remember every single detail, and I appreciated the chance to review it last night.
Okay, but did you realize yesterday when we were talking about it that you had in fact brought it out in your affidavit to begin with?
I don't think that was top of mind, but I accept that it was one of the footnotes. Yes.
Okay, so you weren't caught by surprise that you were being asked to talk about the Finney animal studies yesterday, were you?
No.
Okay, so you wanted an opportunity to review it, but we didn't ambush you with it.
Correct. If I remember what happened yesterday, the question was whether or not the Finney animal study showed retinal hemorrhages. And I think I correctly noted that the Finney animal study showed damage to the lamb's retinas. And the question was that damage the same as a retinal hemorrhage? And having had the chance to review it, I think I understand better the answer to that question.
Which is that it didn't show retinal hemorrhages.
Because no one looked at the retinas of the lambs. They looked under a microscope at what had happened to the retinas. And so they demonstrated damage to the retinas on the microscope, but the methods of that paper never included looking at the retinas. So they didn't see what they didn't look for, which is retinal hemorrhage.
So when I asked you about the language in that particular paper that said no retinal hemorrhages were found, they didn't say we didn't find retinal hemorrhages because we didn't look for them. They just said they didn't find retinal hemorrhages, right?
I don't think that's a direct quote from the paper. No retinal hemorrhages were found. There was very convoluted microscopic findings of damages specifically to the layer of the retina. But I don't think it's fair to say there were no retinal hemorrhages in these lambs. In fact, in the other article that you offered last night, when it reviewed the animal studies, they include their own paper as something that demonstrates retinal hemorrhages in an animal model. Well,
so I don't want to spend all day talking about these studies, but just the studies say what the studies say. And of course, Judge West is going to read the study. Like, let's talk, the 2012 study is already in evidence. Judge West gets to read it, see what it says, right?
Great.
And it goes from Judge West's court to Austin, to the Court of Criminal Appeals, which in Texas is the equivalent of the Supreme Court for criminal cases. And 9 judges there are going to get to read this and decide what it says. Do you understand that?
Okay.
Okay. So what you're saying is that you want the record to reflect when judges read this 2012 Finney study, you want the record to reflect that you are telling them either that it shows retinal hemorrhages or that nobody looked for retinal hemorrhages as part of that study. That's what you want the record to reflect, to be your position on that paper.
If the judges were gracious enough to read my testimony, the summary I would like to give them about how this paper impacts retinal hemorrhages in lambs is that their methods used microscopic dissection of the retinas to assess damage to the retinas of these lambs, and that they found microscopic evidence of damage to the lamb's retinas in this study.
But you understand, and I'm trying not to beat this into the ground. We are talking about retinal hemorrhages, not some other damage to the eye. You understand that's what we're talking about, right?
I mean, you can decide what you want to ask me about, and if you're asking
Okay,
about
well,
retinal hemorrhages,
Okay, are you saying, and you want this
I
court?
think it's already been asked and answered.
Okay.
Let's
All
get
right.
off of this.
Now, we provided you last night with,
yeah, may I refer to a copy of it?
yes, and I'm gonna approach also, can I approach you?
Yes, so the one that we've been talking about is 2012,
2012, yes, ma'am.
and now we're talking about,
2022.
thank you.
Okay, let me just show you this marked copy. Does that appear to be the 2022 paper?
Yes, sir.
Okay, and
So 11 was what then?
Uh,
Defense 11, I thought was the Finney study. It was a Finney study.
maybe I already offered it yesterday, and it's already in before the court as the 2022. But
That's what I need
don't
to
think it
know.
was admitted, yes.
So 11 is here,
I looked
is
at what,
2012. So
Okay.
the defense 11 is 2012.
The defense attorney is doing something crucial here. He's building a record for appeal. By pinning Dr. Lindberg down on exactly what the scientific studies say, and don't say he's creating written testimony that higher courts can review. In post-conviction cases, defendants often argue that new scientific evidence undermines their original conviction, and appellate judges read these transcripts to decide if the science has genuinely shifted or if experts are just interpreting the same data differently.
right.
Defendants 12. Was-
That's his citations from it.
Okay,
And so
that's the email. So this will be 13,
this will be 13.
correct?
And it's entitled Animal Models of Pediatric Abusive Head Trauma by Finney and Blumsberg. Is that correct, Doc?
Yes.
Okay. Okay, so I'm
So
offering
13's admitted,
13. Okay,
and that is the Finney study 2022.
that's correct. Dr. Lindberg, the Finney study 2022 under results said due largely to irreconcilable anatomic species differences between these animal brains and human infants and a lack of resemblance of the experimental head shaking induced by mechanical devices to real-world human neurotrauma, no animal model has been able to reliably reproduce the full range of neuropathologic AHT changes. And did I read that correct?
Yes, sir.
Under results. And would you agree with me? I don't want to keep reading it all, over and over again, but would you agree with me that throughout this paper, they make statements like that over and over again?
I think that's a fair summary of their conclusions, yes.
Okay. And then towards the end, my copy doesn't have page numbers, but at the next to the last page, it says, in conclusion, it's unlikely that any animal model will be able to precisely replicate complete range of brain and ocular lesions used to support a diagnosis of AHT in humans. Do you see where I'm reading that from?
I do.
Okay, so would you agree with me that certainly along with the other Finney paper, do not support the shaking theory as far as shaking causing the conditions seen in shaken baby. You think that what I just read to you means that they concluded that the studies done on lambs, you think that this means it supports the position that shaking causes these conditions?
No,
It does or it doesn't support that?
I don't think this paper addresses the question you think it addresses. You're trying, I mean, if I understand the two questions you just asked me, you said, does this paper answer the question of whether shaking can cause these injuries in humans?
Okay, that's the first question. What's the answer to that?
This paper doesn't address that question at all.
So if you or anybody else made a broad statement that the animal studies, including the Finney studies, support the concept that shaking alone will cause these conditions in a human infant, that would be incorrect. Is that right?
Okay, I understand the confusion we're having here. I was answering the question of what did these authors conclude based on the previous questions. But I think the other question is, what could a reader of this paper conclude from the data that they're presenting?
Okay, well, that's okay. Two separate questions. I understand. Did the authors conclude in this 2022? Well, first of all, this 2022 paper is just sort of a summary of the animal studies to date. Is that a fair statement?
Correct. It's a review paper, unstructured review.
And so the authors of this paper, Finney and Blumsberg, what they concluded is that the animal studies do not replicate the injuries and conditions seen in human infants on alleged shaking.
Correct, with the specific injuries they chose to look for.
Okay,
So
now
that's right.
the specific injuries they looked for included retinal hemorrhages, right?
Correct.
Okay, so now you understand retinal hemorrhages are a major issue in this case that we're dealing with here today.
Yes, sir.
Okay, so they did the Finney and his co-authors did lamb studies and did not replicate retinal hemorrhages in the lambs.
No, I think that's very wrong. And I would refer you to table 1. I think the key thing you have to understand here is their conclusion is no single animal model is a perfect replication of what we see in infants because, surprise, animals aren't human infants. Their brains are different. And so while each of the animal models showed some injuries, and if you look at the second to last line on table 1, you'll see that little plus mark next to the Finney studies under retinal hemorrhages. And that means their conclusion is that their studies did identify retinal hemorrhages in lambs, but they didn't identify ischemic hypoxic neuronal damage in their model. Now that was identified in the Euchre model, but the Euchre model didn't look for retinal hemorrhages. So while each of the findings has been found in some of the animal models, no single animal model is perfect for humans. I think that was their main conclusion.
Their main conclusion is that they were unable, because these were, they say because these are animals, these aren't humans, right?
And
But they were unable to I think they used the word replicate. They were unable to replicate the injuries seen in alleged shaking cases. That's the bottom line of these Finney papers.
Your Honor,
Am I right?
my objection would be.
I apologize if I'm being argumentative.
I just feel like you've asked it, he's answered it. Y'all at some point have to agree to disagree. I don't think you're going to talk him into what you're trying to get him to, and he's not going to get you to see his way. So I understand that you guys have differing opinions about what that study says, and I think I've gotten the gist of what both of you believe it says.
Okay, and I'll move on just to wrap that up. You are on record as saying what you think it says, and the judges are going to read it and figure it out for themselves. Correct. You have said what you think it says. Do you have anything else you want them to hear from you before they look at it and see if what you're saying is right.
I would like to add two small things. I think we're actually pretty close, but the one thing that I would make sure that we add to your summary of the case is the animal studies couldn't replicate the full range of the injuries, which is to say some animal studies replicated some things, others did others, but no one did all of them together in animal studies. And then the second thing I would say is it's not just that animals are different than humans, but the methods they use to shake experimentally are different than what happens when humans are shaken in an abusive situation. Those were the two big reasons they thought no animal model is going to be perfect at that.
And in fact, in these lamb studies, they shook these lambs much longer and more vigorously than anybody's even ever been accused of shaking a human baby.
That wasn't.
Actually, that's also speculation on the part of this about in the history of accusations being accused of how.
So let me move on briefly then to the piglet studies. Now, your affidavit did not cite the piglet studies as supporting the shaking theory the way you cited the lamb studies as supporting the shaking theory. Is that right?
That's correct.
And so is that because you didn't think the piglet studies supported it in the way the lamb studies did?
I have to admit, I didn't reread all the animal studies. I identified one that supported that you could have retinal damage from shaking, and I didn't re-review the code study.
Okay, retinal damage, not retinal hemorrhages though, right? I just don't want the record to get confused.
It's not.
Okay, sorry. Okay, so you didn't cite the piglet studies because you just hadn't studied them enough to determine whether they should be cited. Is that a fair statement?
I don't want my list of citations to imply that anything that's not on that list is not appropriate. I have thousands of papers in my database. I didn't go through each one to see which mattered. A citation to me says this is the support of someone who did the research beyond my own opinion. The lack of a citation doesn't really imply anything about what.
Okay, well, I understand. So, but last night, I presume you had a chance to look at the piglet studies.
I did.
And specifically, what we are talking about is, no, it's saying, can I approach the witness?
Yeah, and can I get 12 and 13? I just don't want it to get mixed up since
Right.
you're using the.
Dr. Lindberg, let me show you what we've marked defendant's exhibit number 14. And are you now, at least as of last night, familiar with this study?
I am, yes.
Okay, and let me read the title of it. It's cyclic head rotations produce modest brain injury in infant piglets. We would offer.
It's admitted.
I do actually. That's the one paper.
Oh, here, I've got it. Now, let me first turn to the second page. No, this is written by Brittany Coates, Gil Binnenbaum, and it lists a bunch of names. Cindy Christian. You know some of the people that wrote this article, don't you?
Yes, sir.
Among the articles here, who are the ones that you personally know?
I know Gil Binnenbaum, Cindy Christian, Anne Christine Duhame, and I know the others by reputation, but not personally.
And some of these people are child abuse pediatricians, is that correct?
At least one of them is.
And Dr. Christian, is that?
Yes.
Okay. Now, if you turn to the second page of this article and down at the bottom of the first column, it says, in summary, within 6 hours of shake. And first of all, this is a paragraph discussing the Finney studies. It's laying the groundwork to discuss the piglet studies by discussing the lamb studies. Is that right?
This is the background section of the paper. It summarizes work that's been previously published.
Okay. So this particular paragraph, what I'm reading now, is referring to the Finney lamb studies. And they're saying in the Finney lamb studies, in summary, within 6 hours of shaking, this large animal model with uncontrolled repeated head movements did not produce widespread hypoxic ischemic brain injury, subarachnoid or subdural hemorrhage, and retinal hemorrhage, which are characteristics often noted in AHT patterns attributed to shaking. Okay, did I read that
Yes, sir.
correctly? And so are they saying, so Dr. Coates and Dr. Christian and the other authors here are saying that when they looked at the Finney studies, they're telling us what the Finney studies.
That is what they're saying in their background to support the reason to do additional studies. Yes.
And I take it you disagree with what they're saying, the Finney studies.
I don't disagree with their something.
Okay, so you are in agreement with exactly what I just read.
Yes, within 6 hours of shaking, this animal model with uncontrolled repeated head movements did not produce the specific findings you mentioned.
Okay, now let me go back to the first page of this study, this piglet study, under the abstract, and it says all findings were at the mild end of the injury spectrum with no significant findings at 6 hours post-injury. You see where I'm reading?
I see where you're reading and you're reading
Okay.
it correctly.
So when you talk about the injuries in shaken baby syndrome, and particularly the way the injuries have been described in this case, in the Garner case, they are certainly not, they're not mild, are they?
No, the injuries in this case are not mild.
So when they do these studies and they shake these baby piglets, and if they create some injuries and they're mild injuries, they have not created the injuries that are seen in the alleged shaken baby syndrome.
I would just really be careful about oversimplifying. This particular model did not perfectly replicate the injuries we see in Kalen Garner. I don't think it would be correct to say that this particular model didn't identify the injuries commonly associated with the shaken baby syndrome.
Are the injuries commonly associated with the shaken baby syndrome at the mild end of the injury spectrum?
This model created injuries that are at the mild end of the injuries.
Okay, my question is, are those the injuries that you see in shaken baby syndrome cases?
I don't like the term shaken baby syndrome. Abusive head trauma has a range of severity from more mild to more severe. There are some cases of abusive head trauma that have injuries similar to what was replicated in this animal model, but this animal model did not replicate the severity of injuries we saw in Kalen Garner.
And just, and I don't want to get back into this circular argument about shaken baby syndrome versus abusive head trauma, but what we're talking about here, as you understand, is shaking alone in the Garner case.
I'm perfectly willing to address the question of what injuries can be caused by shaking alone.
And the testing they did in this piglet testing was concerning shaking. Isn't that right?
Yes.
Okay, so when they're saying all findings were at the mild end of the injury spectrum, they're saying the shaking that they did on these baby piglets only produced injuries at the mild end of the injury spectrum.
Yes.
I mean, it's pretty simple, right? I mean, it's not simple.
That's
And that's a very bad way to put it. But that language itself is pretty simple. That what I just read.
I think that's a
Mild end of the injury spectrum is
He
not a
disagreed with your
I'm
question.
sorry.
So
Okay.
let's go on.
All right. And it also says in the same abstract, no OI. What is OI?
ocular injury.
Which means retinal eye injury of some kind. But I'm just asking you about, excuse me, I don't mean to interrupt, but I'm just asking you, I'm asking you about that one sentence. No OI was observed. What does that mean?
OI means ocular injury.
So no eye injury was observed.
Can I review the paper?
Yes, but that's fine, but I'm going to ask you when you review it to answer my question on that one.
So there's two ways to answer the question. I want to make sure I'm being as clear as possible. One is, what's a plain reading of the sentence you just read to me? And the second is, does that imply their results? And I just remember this as showing injuries to the retinas, and I want to be very careful, so I'm just going to review what they actually found.
Okay, and if you want to disagree with the author's conclusion of their own paper, that's fine. But I
He's
just need...
asked for a minute to review it.
Okay, sorry.
Let's give him a minute to review.
I'm not seeing where they report their ocular findings, except that sentence in the abstract, which I agree with you, says there were no ocular injuries identified.
Okay, so let me ask you to turn to, it's page 244 of the copy I have, and I hope yours matches it, but it's under the section called discussion.
Yes, sir.
And if you'll go down to the bottom of, well, it's the bottom of the second paragraph, it says there was no ocular.
The second paragraph of the discussion.
Right, the bottom of the second paragraph.
There it is.
So it's saying the same thing. I mean, it's saying the same thing that's in the abstract. Correct?
Yes, sir. Yep.
Okay. So you're saying they didn't discuss it any further. They just gave us their. Now, let me talk a little, kind of shift gears. You'd be happy to know I'm through talking about. Let's talk about shortfalls in general. I think you acknowledged yesterday you'd heard about the Rourke case just because it's an issue here.
Can I just ask why we're talking about shortfalls? Give me the reason before we go.
Mr. Coleman brought out yesterday, and I think it was primarily through Dr. Yu, that the bump on the door jamb when Mr. Garner was holding the baby is similar to a shortfall. That's the reason why I'm getting back.
I just want to make sure that that's also if because I let him talk about it in that only that specific instance. Let's make sure that
The defense attorney's strategy here is surgical. He's using the prosecution's own experts against them. The piglet study was authored by leading child abuse pediatricians, including one the witness personally knows, yet it found no eye injuries and only mild trauma from shaking. In post-conviction hearings, new scientific evidence can warrant relief if it undermines the original conviction's factual basis. The attorney isn't just questioning one study. He's building a pattern showing the scientific foundation for shaken baby syndrome has shifted dramatically since the original trial.
that's where Dr. Lindberg is too when you're asking that question.
Okay, Dr. You heard what I just said, that Dr. Yu said that those were comparable incidences, shortfalls and the bumping of the baby's head on the door jamb.
I heard you say that.
Okay, do you agree with that?
I think, again, it can be very complicated. Different studies have used different definitions for what counts as a shortfall. Trauma surgeons often consider a shortfall something less than 18 feet, 1.5 stories. And I don't think that's comparable to hitting your head on a door jamb. There are other shortfalls that are much more serious than the reported hitting the head on the door jamb. So I don't think it's fair to say that all shortfalls are equivalent to hitting your head on the door jamb. But I do think we can get insight from reading shortfall literature about what we would expect from a minor bump like that.
Okay, and you agree that there is shortfall literature that supports the idea of a broad range of injuries can be caused by shortfalls?
Yes, sir.
Okay, even death.
Yes, sir. Within the idea that there are many different injuries that are encompassed within the broad label of shortfalls.
And I'm not going to spend much time on this, but I just want to clarify this. Mr. Coleman asked you something about the Atkinson-Starling study about childhood falls with occipital impacts.
I don't remember that, but I did review that article last night.
I mean, prior to last night, were you familiar with that article?
Yes, sir.
And can you just tell us in brief summary what that article established that maybe was new?
The article was a survey article. So it was an appeal to the Helfer Society, which is a professional society of physicians who spend a lot of their time dealing with child abuse pediatrics. And it asked, has anyone seen cases that might look like abusive head trauma that were ultimately determined to be related to impacts to the back of the head, what we call the occipital part of the head? So they asked everybody in the society, do you have any of these cases? And ultimately 8 people shared the details of those cases that were carefully investigated for the possibility of abusive head trauma, ultimately determined not to be abusive head trauma. and they looked at the range of injuries that happened. They identified in these 8 cases that the 8 children had subdural hematomas, and one of these children even had a very serious fatal injury as a result of a fall onto.
Now, no, and I apologize if I'm being repetitious, but will you tell the judge what the Helper Society is?
The Helper Society is a professional organization for physicians that work in child abuse pediatrics. So every specialty has its own organization. The American Academy of Pediatrics, ophthalmologists, emergency physicians have each of their own societies. This is for child abuse.
Are you, and maybe you don't qualify for membership in that. Are you a member of
I
that?
am indeed a full member of
Okay.
the Helper Society.
Okay, so do you recall, well, first of all, let me ask this. Dr. Norrell Atkinson, do you know her?
I do.
And she is a child abuse pediatrician, is that correct?
I believe so, yes.
Do you know where she's currently working?
I don't off the top of my head.
Okay,
tell her.
and Dr. Suzanne Starling, I'm sure you know her, is that correct?
I know Dr. Suzanne Starling.
And she's also, I mean, she's a well-known child abuse pediatrician, right?
Correct.
I don't, people call me seasoned. Would you say she's seasoned as a child abuse pediatrician?
Dr. Starling has significant experience.
Okay, okay, we'll say it that way. So these were, and then the third author was a doctor from Finland or Norway, I believe.
The Netherlands.
The Netherlands, okay. So these were people who worked in the world of child abuse pediatrics, correct?
Correct.
When this survey, so we're talking about 2018 is when this paper was issued. So I guess at some point earlier in 2018 or maybe in 2017, their survey questions went out to the Helper Society members.
Yeah, and it wasn't a survey like everyone fill out this form. The Helper Society has a listserv where people can ask, because even in big centers, there's usually not a large group of child abuse pediatricians who practice together like there are emergency physicians. If I have a question about emergency medicine, I walk down the hall and knock on my colleague's door and say, have you ever seen anything like this? What do you do in this situation? The Helper listserv gives that sort of support to people who practice in this field with really high stakes to make sure that we can practice according to the same standard. And so this was just an email that went out on the list and said, has anyone seen this?
Do you recall seeing that email in back in those days when you were working on these?
I don't recall seeing it, but that doesn't mean, I certainly could have forgotten.
But you weren't one of the doctors that submitted cases.
I was not.
Okay. Did this seem to you like a good thing for the child abuse physicians to be looking into?
Yes, I think this is a good study.
And okay, so it's a good study. And the bottom, let me ask you some of the results as stated in the article, and tell me if I'm accurately recounting this. They said that childhood injuries, the childhood injuries that they saw in the cases they looked at, all mimicked findings seen in abusive head trauma.
I don't know if that's a direct quote, but that seems consistent with their conclusion.
Okay. And they said that of course, these were all cases, like you said, where it was either looked at by CPS or the police, and it was determined that these were not abusive head trauma cases. These were actually shortfall cases, right?
Correct, yes.
And so these authors said, if witnesses to the events had not been present, there would have been a high suspicion of abuse in these cases. Do you recall them saying that in this article?
Yeah, I think they said if witnesses had not been present, it would have been very reasonable to have a high concern.
Okay. And you agree with that, I guess, right?
Yes.
And do you agree with the conclusion reached in these cases that the fact that there were witnesses who could attest to these being shortfall cases took care of any suspicion or concern about child abuse?
I want to be careful not to judge these specific cases that I didn't look at, but I am certainly willing to believe that of these 8 cases, at least a very strong majority was not abuse.
And they also said if a pediatrician or medical examiner is confronted with a child with a subdural hematoma and retinal hemorrhage and a history of a fall with an occipital impact in the absence of other signs of maltreatment, accidental injury should be considered. Is that am I accurately recounting what their conclusion was?
I agree with your reading. I agree that that's what they meant, and I think that's a reasonable conclusion.
So, am I correct that it is a very high percentage of childhood head injury cases where what the caregivers are telling the medical personnel or the police is that it was a short distance fall? That happens all the time, right?
Short distance falls are very common, yes.
They actually happen all the time.
Yes,
right?
sir.
But frequently, because of the seriousness of certain injuries, they're disbelieved. Is that a fair statement?
No, I think the vast majority of the time when a child experiences a shortfall, they never present to medical care. The vast majority of children who present to medical care after a shortfall are believed, and that's what happened. It's very uncommon for a child to have such significant injuries where we would say, I'm not sure I buy this history of a shortfall.
But Dr. Atkinson and Dr. Starling seem to be implying, or at least suggesting to the doctors working in this field, to be a little more open to the suggestion from the caregivers that there was a shortfall. They're saying, take it a little more seriously with more of an open mind.
This is exactly the sort of thing we talked about yesterday about what is a case series for. Is it possible? Their conclusion is it's possible to have these sorts of injuries after an accidental shortfall, but they can't go beyond that. They can't say how often it happens or whether it's likely or anything.
But I mean, they are making a suggestion. The whole point of this is to make suggestions to
Your
the.
Honor, I think at this point we're getting to the argument.
Well, I also think he's agreed with you.
Okay.
So,
Well,
I think-
one further question, if
Sure.
I can, Your Honor, on this study. You mentioned a child died, one of them on this study. Would you agree with me if the injury where that child died, obviously it must have been a serious injury, right?
Yeah, the injury that was described, injury means two things. One is the event, one is what happened to the body. And both the event that's described and what happened to the body that's described are both very severe.
So if that incident had not been witnessed, there's a very good chance that caregiver might have been prosecuted and sent.
The mechanism that's described, it's impossible for it not to be witnessed because it involved two other people.
The Atkinson-Starling study represents a critical shift in how courts evaluate shaken baby syndrome evidence. When peer-reviewed research shows that accidental shortfalls can mimic abuse injuries, it creates reasonable doubt that didn't exist when defendants like Garner were originally convicted. This is why post-conviction relief exists, to correct verdicts when science evolves.
No, I'm sorry, say that again.
Standing in the front yard with multiple other family members, that's not, said. One child pushes another child who then fell backward onto the 16-month-old, who then fell from a standing to a seated position and then hit her head. So the nature of the injury implies two other witnesses. It's impossible for that injury to happen without a witness.
Well, I guess my point is, if a child came into the hospital with the injuries that child had, and a caregiver came in and told this story and said, that's what happened, and I saw it happen and I'm the caregiver, there's a very good chance that story would have been disbelieved and that caregiver would have been prosecuted.
Oh, that involves several steps. If the child came in with these injuries and that story, the first thing we'd say is, let's talk to those other kids and make sure they're okay and see if they can tell us what happened.
So you don't agree that, well, let me move on. Okay. So I know you reviewed the trial testimony, and I think you said you reviewed the medical records in this case. And one of the issues in the new science discussion concerning shaken baby syndrome is the idea of a lucid. And so there has been multiple court opinions that have found that there is new science establishing that there can be a lucid interval of some period of time after whatever event occurred that caused a child to have the conditions they have. You understand that that has been discussed, at least in the legal world.
I'm not familiar with what courts have found. I understand the question of the lucid interval has been discussed in many different courts.
And so if it is possible, as some of these courts have said, to have a lucid interval of 5 hours, 6 hours a day, 2 days, from the time whenever something happened that caused a child's condition to start developing, a lucid interval, meaning the child was functioning at least in some way that wasn't obvious that they were seriously hurt. That if that's true, if you can have a lucid interval, then something could have happened to the child in the Garner case at some point in time when Luther Garner wasn't the sole caretaker of this child.
So many layers to that question. A, I don't know what courts have found. B, I'm not willing to agree scientifically with an unnamed court in an unnamed decision about a lucid interval. C, lucid intervals apply to a specific injury, and whether there can be a lucid interval in any child with an epidural hematoma or a subdural hematoma is a different question to whether or not a lucid interval could have happened with Kalen Garner with his severe diffuse brain injury. So in summary, I do not believe that it is reasonable to suggest a lucid interval for Kalen Garner, given the specific injuries identified in him in the medical record.
And you understand that Dr. Stein, and maybe Dr. Moore too, but you understand at least Dr. Stein in this case testified in a general global sense, no such thing as a lucid.
I don't remember specifically whether Dr. Stein meant in every single case of abusive head trauma or the specific case of Kalen Garner. I would agree with the assessment that a lucid interval is not plausible in Kalen Garner's injuries.
But you would not agree with an assertion that there can never be a lucid interval when a child has any combination of a retinal hemorrhage, brain injury, and a subdural hematoma.
There are certainly some children with brain injuries who may have a lucid period.
Okay, so if some testimony was saying could never happen, you would disagree with that.
For any child with any brain injury, yes, I would disagree with that.
Okay. Now let me talk a little bit more. I think, tell me if I misunderstood your testimony from yesterday. You seem very dismissive of the idea that biomechanical engineers have anything to add to.
An oversimplification of what I said.
Okay. Do you think biomechanical engineers have anything to add to this discussion?
I think that's been asked and answered yesterday, Judge.
I think we went through it quite a bit yesterday, and I have a good fight too with and biomechanical engineering and these types of.
Okay, Judge, and I don't want to get contrary to what you have. I would like to ask him about 2 court cases that have addressed this very question, and ask him what he thinks about the rulings in those.
The lucid interval debate exposes how trial testimony can become fossilized. Dr. Stein's absolute denial that lucid intervals exist, now contradicted by evolving science, may have locked the jury into a specific timeline. Post-conviction relief hearings under Michigan Court Rule 6.502 allow defendants to challenge convictions when scientific understanding fundamentally changes.
Those court cases. The very question meaning, does biomechanical engineering have a legitimate role to play in determining the validity of the shaken baby syndrome hypothesis?
My objection would be his second guessing a ruling. If he wants to opine on biomechanical engineering, that's fine. But to ask him in the context of agreeing or disagreeing with a court ruling.
I don't think that's going to help me with what I need to do. We went through that yesterday, and I'll make sure and go back through the transcript. Feel like the answers would be.
and let me, maybe I'm not clear on the timing. You have been working in the field of child abuse from a medical standpoint for how many years?
I became interested in it as a medical student. I observed and got some training starting in 2001. I started seeing cases myself in 2006, so 20 years.
Okay. And you understand, we don't need to go back through it again, but you understand what Dr. Stein testified about as far as saying the injuries the child had here were caused by shaking and nothing else. You understand that was his testimony.
I understand.
In the course of your career working in this field, have you ever given that kind? And I assume you never intend to give that.
Hard to know. I can imagine some cases where I would say this is clearly shaking. More and more we have video evidence of people shaking. We have witnesses. So there are some cases where there's pure shaking.
But you have, but my question is, of course, you said you have never given that testimony. Can you anticipate that you would ever come into court and say, this injury was caused by shaking and nothing else could have done?
It's hard for me to predict the future, sir.
Okay, well, I understand. The truth is, you don't know what happened in any particular case with any certainty because you're not there.
Right. I can never know exactly what happened, but I do sometimes feel confident saying that I know what didn't happen. I can say that this, based on my experience with accidental and abusive injuries and my understanding of literature, that some things are not possible.
Okay. Now, let me talk for just a couple of minutes about retinal hemorrhages. So, I assume you agree that at least the approach to retinal hemorrhages has changed over time.
Yes.
And what I mean by that is that Dr. Stein said, kid has retinal hemorrhages, shaking did it, nothing else could have done it.
I think that might be an oversimplification of Dr. Stein's reasoning.
Okay, but nevertheless, I guess the court can read what he said, but nevertheless, saying that a retinal hemorrhage is caused by shaking and nothing else, that is not the current state of the science in concerning retinal hemorrhages.
Correct. My only quibble would be, is that what Dr. Stein was saying?
Okay.
Any retinal hemorrhage automatically equals abuse. He would have been wrong to say that, and if he said that, that is not something I would agree.
But there is some argument made now that certain kinds of retinal hemorrhages are caused by shaking. Is that a fair way to put it?
It's very clear that shaking can cause a range of different kinds of retinal hemorrhages, and some children who have been shaken have no retinal hemorrhages at all. I want to make sure I'm understanding your question. There are some patterns of retinal hemorrhages that are more concerning for shaking, but I agree that you could never show me a picture of a retina and I would say, I know what happened.
But that's what Dr. Stein did in this case.
I would quibble with that. Dr. Stein was a clinician who cared for Kalen. So he knew, and maybe he just forgot to say it because it seemed so obvious to a clinician, that Kalen didn't have meningitis, that Kalen didn't have leukemia, that Kalen didn't have a TV crush injury on him. He knew the pattern of retinal hemorrhages that Kalen had. And so I'm willing to believe that Dr. Stein said these retinal hemorrhages in this child, to me, are indicative of shaking or abusive head trauma. And that's something with which I would agree.
And let me just ask a couple of more questions. And have you, when you filed your affidavit or you submitted your affidavit in this case, the other state's doctors also submitted affidavits. You're aware of that?
That's my understanding.
And have you seen the other affidavits?
No, I have not.
So you hadn't seen Dr. Edwards' affidavit, for instance?
I saw a draft of Dr. Edwards' affidavit. I don't think I saw the file.
So you said you saw a draft of his affidavit, and I think Dr. Yu said the same thing. So did Dr. Edwards send y'all all drafts of his affidavit for comments?
No, I was not solicited for comments on Dr. Edwards' draft. I don't know how I don't remember who sent it.
But you saw a draft of his affidavit before it was finalized?
That's my understanding.
Okay. Can I approach the witness?
Yes.
I'm going to show you, and I'll tell you that this is a page from Dr. Edwards' affidavit, and I understand you can't verify that this is his affidavit, but it says in his affidavit, irrespective of whether the shaking was done to awaken Kalen or to calm him, shaking is a likely mechanism of his injuries.
May I just read?
Sure. Now
That's-
I'm just giving you a one page of it. I haven't
Yeah.
given you the whole thing. And let me also show you a page from the trial testimony of Dr. Stein, and I'll just read this, and it's on page 114 of Reporter's Record, Volume 3, when Dr. Stein was testifying at the trial. And he was being asked questions about the confession or the statement that Mr. Garner made about shaking. And the question was, and it's the prosecutor reading Mr. Garner's statement. And it said, I remember holding him, shaking him, trying to get him to respond to me. And then the prosecutor said, I guess my question is, if a person were to shake a child to try to get it to respond, get his attention, is that the type of shaking we're talking about that causes injuries? Dr. Stein said no. Okay. I'm going to ask you some questions about this. Do you want to look at it any further?
No, that's
okay. Now, would you agree with me that Dr. Stein is saying Mr. Garner said about the shaking? He said, I'm taking what he says about the shaking. That is not what I'm talking about as the kind of shaking that causes these injuries. Is that a fair summary of that?
I agree with that characterization.
But on the other hand, Dr. Edwards says that regardless of why he was doing the shaking as described by Mr. Garner to the police was a likely mechanism of his injuries.
I'm hesitant to speak for Dr. Edwards, who will be testifying later, and you could ask. So I think another interpretation of that might be my understanding of the injuries that Kalen suffered are likely to have resulted from shaking.
All right, but if for purposes of my question, if what Dr. Edwards is saying is the shaking as described by Mr. Garner is a likely mechanism of the injuries, would you agree that that's at least one possible interpretation of what Dr. Edwards?
Again, I think you should ask Dr. Edwards what he meant.
Okay, well, let me ask my ultimate question. If Dr. Edwards is saying, if he's saying, and I understand you're not saying this is what he's saying, but if he is saying that the shaking as described by Mr. Garner is the likely cause of the injuries to the child, then he is in opposition to what Dr. Stein said.
I hope this is enough of an answer. I'm going to try and be as clear as possible. I don't know what mechanism of shaking is described by I was shaking the child to try to get his attention. I think that could include a very minor shake. I've dandled my children and my nieces and nephews on my knees, and that is a form of shaking, which I'm quite confident would not cause the injuries we're discussing today. I can also imagine someone vigorously, violently shaking a child and then telling somebody else, I was just doing it to get their attention. What I will say, my belief is that the sort of shaking that causes the injuries we see in Kalen Garner is extremely violent and would not be confused by a reasonable observer as a benign act.
That's in fact the American Association of Pediatrics definition, what you just said.
I think the AAP has endorsed that sort of thing. Yeah.
And so when Dr. Stein said what Mr. Garner said he did on shaking, when he said that's not what we're talking about, you agree with that, is that right?
Yeah, again, I don't I can't get in the head of what Mr. Garner was describing or what happened in that moment. Either the nonviolent type of shaking isn't what happened, or the type of shaking that is describing was really violent. But what led to Kalen's injuries was extremely violent.
Well, and this is a difficult concept for me to really even explain. But when we're talking about a confession, okay, we're saying, did the defendant confess to committing this? What I think we're talking about is did the defendant say whatever the harm that was caused in this crime, I did it? That's a confession. Do you think that's when you say confession, do you mean something like that also?
I think that's
Objection, hold on a second, Doc.
Sorry.
I think that what constitutes a appropriate or inappropriate confession is outside of the purview of this witness's.
And if I could respond to that, Judge, Dr. Lindberg said yesterday that one of the reasons why he believes that shaking can cause these injuries is because of confessions.
And I will concede that, Judge, but not to the extent to where he's able to opine on what constitutes an appropriate. He may have his own opinion, but as far as defining it, I think that's outside of his.
I guess where are you headed with this?
Where I'm headed is Lindberg or other state's witnesses in this case or other similar cases, if they contend, as they do, that that one of the main bases for their belief that shaking can cause these injuries is that perpetrators have allegedly confessed. I understand that that's what his position and other doctors' position is.
I would ask you to first, I don't know that anyone that I've heard has testified that the main basis for a belief is confession. I think it has been testified to that it is one of the potential circumstances that's taken into consideration, but I don't know that I've heard, and I may be wrong, Dr. Lindberg say that it is the main basis of his. So if you want to get there first, but I don't want you throwing words in that have not been testified to.
Okay, can I approach the witness?
Yes.
Okay. Now, Dr. Lindberg, we were earlier talking about your affidavit, and I apologize, it's all marked up, but it's the only copy I have. Does this look like your affidavit? And Your Honor, this is already in the court's record.
Sure.
It's been filed. Dr. Lindberg, I'm going to read you just a little bit out of this paragraph. And this is your words. The assertion based on biomechanical reasoning that violent shaking is not capable of causing damage to an infant brain is, to say the least, not generally accepted. The overwhelming majority of clinicians who care for children agree that violent shaking is not only capable, but likely to be the cause of Kalen's injuries. The idea that shaking can cause these injuries is supported by confessional data, animal data, and by reports of injuries occurring in shaken adults. So did I read that correct?
Yes.
Okay, so if I understand what you're saying, you are saying that there are three sources, and I'm not saying that you're saying this is all there is, okay? But you have identified for the court three sources of information that your position is shows that shaking can cause these injuries. Number one, the one you list first, is confessional data. Number two, animal data. And number three, reports of injuries occurring in shaken adults. Am I correct that those are the three things you identified?
That's correct.
Okay, I'm not going to talk about animals anymore.
Oh, thank goodness.
But you listed confessional data at number one as something that proves you can cause these injuries by shaking.
Yes, sir.
So you believe that? I presume it's in your affidavit.
Yes.
Okay, so Your Honor, that's why I want to talk to him about it.
But
Your question was that a whole group of doctors, that it was their main basis. So I'm going to ask you to be very careful with the generalization of your questions, making something sound different.
Well-
He said it, but he did not say, from what you just read, that it was the main basis. I think that's my quibble.
If I may add, Your Honor, what my concern is also is conflating what counsel may believe to be a legal definition of a confession with the opinion of this medical.
Now, I'm gonna let, yeah, I mean, you can question them about it. I don't want I want the record clear. So if you ask a question that said main basis, that's not in fact what the testimony said, or in fact what his affidavit said.
Okay, well, I have a question along those lines,
Sure.
if I can.
Yeah, absolutely.
Dr. Lindberg, you know who Dr. Carol Jenny is, right?
Yes, sir.
And just tell us briefly who Dr. Carol Jenny is.
She's a child abuse pediatrician. She's retired. She's done some very important research in our field.
And are you aware that in the Del Prete case from federal court in Illinois on a shaken baby syndrome case, Dr. Jenny testified that the main source of support for the shaking only theory is confessions. Were you aware of that?
I wasn't aware of that.
Do you think that? Do you think the main source of support for the shaking only theory is confessions?
No.
What do you think, just to be clear, I read from your affidavit, are you saying that there are three main sources, the three you have in your affidavit?
I don't want to be exclusionary, but those are three very important things. And I actually think we agree on the importance and some flaws in confessional data.
Okay, so are you telling us, and did you tell us in your affidavit, that when a court is deciding whether or not the shaking only theory has any validity, when the court is wrestling with that issue, they should look at the confessional? So, Your Honor, based upon that, I want to know what he means by confession.
And Judge, I don't have any objection to finding out what he means about.
Yeah.
With regard to a confession. What I don't want to do is conflate that with some type of a legal definition or a legal standard of confession.
Go ahead.
Okay, so when you say confession, what do you mean?
In my experience,
And excuse me, I don't mean to interrupt. We're looking for your definition of confession. Just
Yeah.
that right now.
I'm sorry that I don't have a Webster's dictionary definition. I can remember a very specific case where a child came in with serious injuries and the assertion.
Your Honor, I'm gonna
Yeah,
object.
he's answering.
I'm gonna
Okay.
object to him not answering the question.
I think he answered it. He doesn't have a Webster's dictionary definition.
I'm not, and Your Honor, can I ask him? You understand, I'm not asking you what is the Webster's dictionary definition of confession. I'm asking you, what is your definition of confession?
What I mean to say by that is that I don't have a definition that is carefully thought out that I want to be, held to. Oh, that doesn't count. Oh, this does count. I understand that there are differences, and those differences may come up in research for what counts as a confession. In this case, someone might characterize what Luther Garner said about I was shaking my child to gain his attention as this man has confessed to shaking his baby. That is not my interpretation of that. And I think if we did a research study looking at 100 confession cases, some researchers might include this case and others wouldn't. And I don't have a definition that I would put in a method section for a paper that says this is what counts as a confession. And so I just can't come up with that definition off the top of my head. I have experienced in my life real confessions, and I could describe them if you will.
Let me just say this. Would you agree with me, and just sort of in closing about confessions, that in addition to all of the other problems with confessions, what you have just identified to us is that even in the medical world, the child abuse pediatric world, people don't even mean the same thing when they talk about confessions?
I would agree that if you're looking at literature about confessions, that's a very important question you have to ask and make sure that you understand what definition people are using.
Okay, I'll pass it with this, Sean.
Thank you. Anything else, Mr. Coleman?
Just
Moving as fast as I
You're
can.
good.
Dr. Lindberg, given all of this discussion about various publications and articles by counsel for the applicant, is there anything with regard to what has been presented to you, provided to you, to review about from applicant's attorneys that has either changed your opinion as it relates to shaken baby syndrome or abusive head trauma in infants, inclusion that you reached in? So is there anything that you'd like to add or to elaborate in that regard?
And Your Honor, I don't think that's a proper question. Just anything else you want to say?
If there's something specific Mr. Yudishin asked that Dr. Lindberg did not have an opportunity to explain, kind of like we did with Dr. Glasnick, I would allow that.
Do you need a pointed question from me or?
Not necessarily,
Okay.
but if there's something specific that you weren't given an opportunity to explain, then I would give you that opportunity to do that.
Thank you, Your Honor. I'll try and be brief. I just want to talk about, as we did with case series, what is the point of animals? Doctors have been using animals to study disease for over 100 years. And it's not to decide whether or not a disease exists or what the mechanism is. We don't use.
The defense attorney has just exposed a critical flaw in how medical experts use confessions as scientific evidence. Dr. Lindberg admits he has no working definition, yet his affidavit lists confessional data as the first pillar supporting shaken baby theory. This is courtroom alchemy, turning ambiguous statements into scientific proof without agreed standards. When experts can't define their own methodology, courts must ask harder questions about reliability.
Use pig models to determine whether or not people have heart attacks. We use pig models to figure out how to treat heart attacks. Okay, look, if we block this artery in a pig's heart, it looks like they have a heart attack on their EKG, on their pathology. So let's go after these blockages in arteries when it comes down to fixing heart attacks. With shaken baby syndrome, the point, or abusive head trauma, the point of an animal model is, why do these neurons get injured? Is it the pressure from the blood? Is it the shearing? Is it seizures? Is it rupture of those connections? How can we help these babies have the best outcome once we diagnose it? But just like the
prosecutor's last-minute document dump reveals a classic courtroom tension: surprise evidence versus fair notice. Michigan court rules require advanced disclosure so both sides can prepare, but judges retain discretion to admit late evidence if the opposing party isn't truly prejudiced. Here, the defense complains but can't show harm. The articles were authored by the witness himself. The judge's quick overrule suggests procedural objections matter less than getting to the truth.
experiment before. If an animal model doesn't show a retinal hemorrhage in a lamb or a pig with a specific mechanism of shaking, that's not going to, tell us what's going to happen in a human being. And so, all this animal stuff, it helps me understand that it is possible to cause a retinal hemorrhage or brain injury by shaking a mammal. But people also have told me, I shook this baby and I caused this. There are adults who report they were shaken and they had those injuries. And I think that's much more convincing that shaking is very likely to be the cause of Kalen's injuries.
All right. Thank you, Dr. Lindberg. I want to briefly talk about the characterization of Dr. Stein's report or testimony by applicant's counsel. Applicant's questioning would imply that Dr. Stein based his assessment on there being shaking alone. And I know it's been a while since you reviewed those materials, but would it surprise you that actually he mentioned in his assessment that there was shaking of the body, anterior and posterior? However, the repeated nature of it there was evidence of brain shear to the neurons that got swollen and led to the bleeding behind the eyes. Would that surprise you, or does that refresh your recollection about what you read?
That sounds like a very good summary of what is the likely cause of Kalen's injuries.
So would it be a fair characterization to say that Dr. Stein, based on what I just highlighted there, based his assessment on shaking alone?
I'm sorry, I don't want to summarize what Dr. Stein.
Well, I mean, let me ask it this way. Did Dr. Stein, based on what I just read, mention brain shear of the neurons?
Yes, sir.
Did Dr. Stein mention that those neurons ultimately became swollen?
Yes, sir.
And did he say that the swollen neurons led to the bleeding behind the eyes? I'd like to offer 3 publications I feel compelled to in the interest of completeness and also in balance and in perspective on the record. And I've already marked them, and I've marked them as states exhibits number 1. And if I can, it's with regard to states number 1. Dr. Lindberg, I'm going to show you what's entitled Acceptance of Shaken Baby Syndrome and Abusive Head Trauma as Medical Diagnoses. Date on there, I'm sure there's a date somewhere, but it's authored by Sandeep Narang et al. And some guy by the name of Daniel Lindberg. If you take a look at that and let me know if you're familiar with that, and if that is something that you would rely on either in your practice or in providing expert testimony.
I am familiar with it, and I do rely on it when I provide testimony.
Can you help me with the date that was published? I don't see it right on the face of it.
I think it is 2016.
Okay, very good. Do you have any reason to doubt the authenticity of this document that's States Exhibit number 1? I have States Exhibit number 2 here, the New Science of Abusive Head Trauma. It appears to have been published in 2019. Doctors Dubowitz, Alexander, and again, that guy, Daniel Lindberg is part of that as well. Are you familiar with that stuff?
I am familiar with that paper.
That paper, excuse me, thank you. And is it something you would rely on in your practice and or you're providing your testimony?
Yes, sir.
And you have any reason to doubt the authenticity of this particular document that I'm showing?
No, sir.
And lastly, States Exhibit number 3. It is an article that is entitled Abusive Head Trauma in Infants and Children, and the publication date on it. But again, Dr. Sandeep Narang et al. They were authors. Thank you very much. Looks like it was authored. Are you familiar with that? Is it something that you would rely on either in your practice or in providing expert testimony?
Yes, sir.
You have any reason to doubt the authenticity of this document that I'm showing you?
Yes.
Your Honor, at this time, state offer states 1, 2, and 3. For the purposes of the record, I am tendering to defense counsel for his inspection.
And Your Honor, just a couple of things. Of course, Mr. Coleman had a lot of complaints yesterday that we were bringing up articles that we hadn't told them we were going to bring up. We certainly weren't told they were going to bring these articles up. I'm not really objecting on that basis. I'm just pointing out to the court.
Are you objecting?
I am. Well, let me back up. Rules require some kind of advance notice before bringing up articles. I object that we had not received advance notice on these articles.
That's overruled. They're admitted.
And the second thing, of course, what we've been doing is giving the state copies for themselves of anything we introduce, and they haven't given us any copies of these articles.
Okay, thank you, Mr. Coleman. 1, 2, and 3 states are admitted.
And for the record, I'm providing a copy to.
Mr. Coleman, would you, unless you're about to, are you going to use those or are those just for the, I'm going to put them on here so they don't get mixed up.
Yes, ma'am. I'd like to reference one paragraph in each of those 3 articles, please, and I will be done.
Do you need these back?
No, yeah. Dr. Lindberg, I want to provide you with highlighted portions, a paragraph in each of those publications. The judge and the Court of Criminal Appeals will have a portion that I'd like to draw your attention to. I've highlighted and I've folded to the.
And could I just inquire as to where we're reading so I can follow along?
Yes.
He'll point out the page and paragraph. Let's start with the abusive head trauma in infants and children published in 2020.
Which is stating.
State Exhibit 3. Dr. Lindberg, for the purpose of counsel for the applicant, what page and paragraph is highlighted there, please?
Page 3.
Yes, sir.
The last sentence, sorry, to the middle column, the last sentence of the first paragraph on the middle column. It ends with citations 28 and 29.
And is it a fair summation to say that that paragraph says that sound evidence-based literature supports the conclusion that both inflicted rotational and contact forces to the head can cause brain injury, intracranial hemorrhage, spinal hemorrhage, and or injury and retinal hemorrhage?
It says that in the third column, middle of the top paragraph. That's a direct quote.
Okay, thank you, sir. Now I'd like.
Where I thought.
Sorry, third column, halfway
Oh.
down the top section.
Thank you.
I'd like to turn your attention now to the next article, please. That would be the acceptance of shaken baby syndrome as abusive head trauma.
States 1.
Thank you, Judge. States 1. highlighted portion there, if for the applicant and for the judge, could you reference the page number and the paragraph that that's highlighted there?
Page 275, second column, second full paragraph.
All right, and by way of paraphrasing, does it say essentially that more than 80% of respondents felt that shaking with or without impact was likely or highly likely to produce subdural hemorrhage? And does it go on to say, again, by way of paraphrasing, more than 90% of respondents felt that shaking with or without impact was likely or highly likely to produce retinal hemorrhaging, or RH as they refer to it?
Correct.
And lastly, by way of paraphrasing, does it say that more than 78% of respondents felt that shaking with or without impact was likely or highly likely to result in? And lastly, I'd like to turn to the last article, the new signs of abusive head trauma. There's a lot contained in there. For purposes of our discussion or our questioning, I'd like to focus you on that highlighted paragraph. And for purposes of the judge's purposes and the opposing counsel, what page and paragraph are you talking about?
There aren't any page numbers, but if you go from the end, it's the third page ahead of the references, and it has a section heading that says cerebral sinus thrombosis.
Have you got that, Mr. Yudishin?
Yes.
And again, by way of just paraphrasing, is it fair to say that it says no single peer-reviewed paper has been identified linking cerebral sinovenous thrombosis, or CSV, with other signs of AHT, meaning abusive head trauma?
Yes, sir.
And does it go on to say, by way of paraphrasing, nevertheless, the hypothesis is suggested? That's all I have, Judge. I'll pass it.
Anything else?
Yes, I'm sorry, Joe, Dr. Lindberg, let me ask you first of all about, you were telling the court the purpose of animal studies in general. The purpose of the animal studies that we're talking about here was to determine whether shaking could cause the injuries we're talking about. That was there. So because animal studies are done for some other purpose in some other context, that doesn't mean anything about these studies.
Yes.
Okay. Now, do you recall testifying in New York, probably in 2014, in a case called the State of New York versus Renee Bailey?
Yes, sir.
You actually recall that testimony, right?
I don't recall every word of that testimony, but I remember going and testifying.
Okay, and I gave the state's counsel this morning a copy of the opinion to give you, just to refresh your memory a little bit.
Yes, sir.
Okay, and you recall in that case, and I'm reading from the court's opinion, which we gave you this morning to look at. It says Dr. Lindberg also testified that retinal hemorrhages can be caused by many different types of trauma, but the severity of Brittany's retinal hemorrhages was inconsistent with the fall from a height of 18 inches. Contrary to Dr. Lindberg's testimony, the court finds the testimony of Julie Mack, MD, to be persuasive in that the retinal hemorrhaging seen in Brittany's eyes was consistent with a short distance fall. Did you have a chance to look at that this morning?
Yes, sir.
Okay, so in that case, you gave your testimony about retinal hemorrhages. Dr. Mack, who was another doctor that apparently was testifying on behalf of the defendant there, gave contrary testimony, and the court found her testimony to be more persuasive than yours.
That sounds correct.
Okay, I mean, it happens when you're an expert witness, right?
I suppose.
It goes with the job. Now, do you also recall in that testimony that you gave in the Renee Bailey case, saying that I believe that in rare circumstances, because of an epidural hematoma or space occupying lesion, children can die from the broad category of shortfalls? Does that sound like something you would have said?
That sounds like something I would.
Okay. Now, let me ask you about well, you mentioned the adult studies, and I don't want to, the adult shaking studies, and you did reference that in your affidavit. Would it surprise you that none of us have ever really seen anybody reference adult shaking studies in this context before?
It would surprise me if nobody's referenced them before.
Okay, so like for instance, one of the adult studies, and tell me if you remember this, one of the adult studies was, or cases at least, was something from Italy where a man had passed out, was unconscious, and you know, laid out on the ground, and two of his friends shook him, trying to wake him up or get him to respond. Do you remember that case?
I'm not familiar with that one, and I agree with you that we should refer to these as case examples, not studies.
Okay, so that case example, man passes out, laying on the ground, his friends shake him, trying to get him to respond, and then he dies. Do you remember that?
That's not one of the cases that I was referring to. I'm not familiar with that.
Okay, even if it's in one of the articles that you refer to, you just don't remember that case.
When I talk about adult examples, I'm talking about one paper authored by Pounder, which is easy for me to remember, about a case of intimate partner violence where an adult, a man shook his wife. And I'm talking about a case that's been described of a prisoner that was interrogated by the Mossad by shaking and had the injuries associated with it.
And that's the other one I want to ask you about. So there's a case where the Israeli Mossad had a Palestinian prisoner that they tortured for 3 days, and then he died. And that was attributed that he died from shaking. Is that the case you're talking about?
Yes, and I'd have to refresh my memory, but my understanding was that he also had retinal hemorrhages and subdural hemorrhages.
But wouldn't you agree that it's a little bit of a stretch to take a Palestinian prisoner tortured for 3 days by the Israeli Mossad and then say that that's like shaken baby syndrome?
Well, nothing's perfect, but I think that that is as close an analog as it's closer than lambs.
I'm just going to ask one more question. The Israeli Mossad torturing a prisoner for 3 days is closer than a controlled experiment by professional researchers of shaking lambs. Is that what you're saying?
No one's alleging that Mr. Garner conducted a controlled experiment on Kalen.
But my question is, you want me to repeat my question? I'll be glad to.
I'd love it.
Okay,
Of course this is
are
closer.
you saying Israeli Mossad torturing a Palestinian prisoner for 3 days and then he dies is a better example to use to study shaken baby syndrome than the controlled lamb studies done by Dr. Coates and her colleagues?
I think it's an extremely important example. This is something done on a human being.
Okay, well, I
It's
understand.
extremely violent, if I could finish.
Okay.
And of course, this has something to teach us about what happens to children who experience violent abusive head trauma.
It wasn't a child. The Palestinian prisoner
I
wasn't
think
a
I've got
child.
a point on this.
Oh, okay.
We're spending too much time on things that aren't specific to Kalen.
One final area, I want to talk to you about the acceptance study that you were involved in with Dr. Naray.
Yes.
Okay. And there was I think it's in the record, that was done in 2016, right?
It was published in 2016.
So it was actually the information was gathered before 2016, is that right?
Yes, I think you can find the dates if it matters.
It matters only in the sense that this was more than 10 years ago.
Yes.
You don't need to look for the exact dates. You agree it was more than 10 years ago.
Yes.
Okay. And you would agree that a lot has happened in 10 years, including the Atkinson study about short distance falls, right?
Yes.
And including multiple court opinions finding new science in this area.
I don't want to characterize.
Okay, well, let me just say this. The Atkinson study was published in 2018 after your study here was published, or your paper. Is that correct?
Yes.
Do you think the Atkinson study, if the doctors responding to your inquiries here knew about the Atkinson study, that would have been something important for them to know in deciding how they feel about all this?
Objection, that calls for speculation on the part.
Sustained.
Okay, that's all I have, Your Honor. I'll pass it.
I have no further questions for Dr. Lindberg, Judge.
Any objection to Dr. Lindberg being excused?
No objection.
Show you.
Before we get started with the next witness, let's just take a quick 10-minute break. It's 10 minutes after 10. We'll get started at 10:20. Court will be in a short recess. Back on the record, like everyone is present. I do want, before we get started, just to kind of let everybody know that I'm going to rein all of this in a bit. I think the questions that the Court of Appeals have asked me to answer, we've gotten past that a lot. The Rourke case got us here. All of the argument that probably is going on today is what went on there. They've already said, send it back here. I don't need to get into all of that again. What I have to do is take, and I get that the experts don't agree. We're not going to try to convince the experts to agree with you. You can agree to disagree and then move on to the next question. All right. So I just want, I think we've taken a whole lot of time that probably is unnecessary for what I need to make my decision.
I understand, Judge. Just so I'm clear. I mean, does the court not, my intent with my questioning and testimony is to just give the court a flavor, an idea of the science upon which these experts are basing their opinion on. That's all.
I'm not gonna, my intention isn't to hamstring either of you on what is important. I've already heard a lot, read a lot. I've started looking before this and during the short week we've had at some of the other information. I feel like for my position, a very good understanding of what your positions are, what your experts pretty quickly are getting into now that I've heard several. So I'm not gonna, I don't want you to take it personal if I say, okay, I'm good, let's move on.
The judge's frustration reveals something important about appellate procedure. When a higher court sends a case back, the trial judge must focus narrowly on the specific questions asked, not retry everything. Here, Judge West notes the Court of Criminal Appeals already sent this back from the Rourke case. He's not interested in watching lawyers rehash old arguments. Under Michigan Court Rule 64502, post-conviction relief requires showing new evidence or constitutional violations, not simply disagreeing with the original verdict.
I guess, so try to do what you want to do. If I feel like it's helping me in my decision, I'm going to let you go. I might just kind of slow it down, stop it, redirect a little bit more than I have been so we can get through it. All right.
That sounds good.
Okay, perfect. Mr. Coleman, you may call your next witness.
Your Honor, state called Dr. James Daniels. Your Honor, he hasn't been sworn in.
Thank you. Good morning, sir.
Good morning, ma'am.
Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? And Dr. Downs, you can thank me later for what I just told the attorneys.
Thank you in advance, too.
Mr. Coleman, you may proceed.
Thank you, Your Honor. Good morning, Dr. Downs.
Good morning, Judge.
Would you please state your full name for the court reporter?
James Claude Upshaw Downs, MD.
But you also go by Jamie, correct?
Correct.
Jamie.
That's correct.
Dr. Downs, you're back. Well, what do you do for a living, please, sir?
I'm a forensic pathologist, medical legal consultant. I also am the medical director for the physician assistant program at Charleston Southern University.
Are you board certified as a forensic pathologist?
I'm board certified in anatomic, clinical, and forensic pathology.
More than 33 years of experience in that area?
Actually, I tallied it up, it's 35.
All right. And are you also certified by the National Board of Medical Examiners and American Board of Pathology?
The National Association of Medical Examiners, I'm a fellow of that organization. I'm board certified by the American Board of Pathology.
How many states are you licensed to practice medicine in, sir?
Georgia, South Carolina, Alabama.
Have you been the chief medical examiner of the state of Alabama?
Yes, sir.
And director of the, please tell the judge about your involvement in the Shaken Baby Alliance, if you don't mind, sir.
So I am a consultant with them. I regularly do trainings for that organization. And I've known the executive director, probably 25 years.
And it goes without saying that you, over the course of your career, you testified in court before?
Yes, sir. Many times, as recently as last night.
Yeah. In fact, you're in the middle of a trial in California, correct?
Sir, they just released me
All right.
at 7 p.m. your time last night.
Very good.
We appreciate you getting here.
So do I.
And testified on
Many occasions. I've been given sworn testimony in probably 20 states, also federal courts, military, hearings, given sworn testimony before subcommittees of the U.S. House, U.S. Senate, as well as before the National Commission on Forensic Sciences.
And lastly, you've provided expert testimony in the Robert Roberson case out of Anderson County, Texas, correct?
That's correct.
That deals with the post-conviction writ involving a shaken baby case as well, right?
That's correct.
You've had an opportunity pursuant to the request of the district attorney's office to review a case file related to a deceased. Those records, if you recall, what did they include?
Transcripts, medical records, autopsy records, scene photographs, autopsy photographs.
And after reviewing those records, did you prepare an affidavit summarizing your conclusion or conclusions?
I did.
And by way of summary, if we could walk through that affidavit for a determination that there was an abrupt onset of physical signs and symptoms of massive acute brain swelling and unresponsiveness, along with pathologic,
Yes, in a very young child.
a 2-month-old, in fact.
Yes, sir.
Could you unpack that for the judge? Massive acute brain swelling.
The brain got fluid on it and got too large to function normally inside the skull, puts pressure on the brainstem and shuts down vital systems.
Unresponsive and pathologic posturing.
The neural pathways are impacted, so there are positions of the body, decorticate and decerebrate. That's what posturing means. It's just how your hands are positioned.
Based on your review of the file or the records, you also determined there was hypoxic ischemic encephalopathy. That's essentially oxygen deprivation and or limited blood flow, correct?
Hypoxia is low oxygen, ischemia is no blood flow.
And you also made a determination that there were retinal bleeds. How would you characterize those retinal bleeds?
Too numerous to count.
And the judges heard testimony about numerosity of retinal bleeds and it being multi-layered. In your training and experience, what are those things indicative of?
Well, they're not seen very commonly. The only place that we commonly see that would be in cases like this of what was formerly called shaken baby syndrome, now called abusive head trauma. In my world, multiple blunt force injuries. The blunt force would be an acceleration, deceleration.
And I want to spend just a little bit of time on the injuries, because to characterize that as blunt force injuries in the context in the world that we deal with in the criminal court realm, when we hear the term blunt forces, we think of like infliction of an injury by like a baseball bat or something that you're using as like a club or something to hit. You're talking about blunt forces in the context of acceleration and deceleration. Please elaborate on that.
Sure. So I'll give you an analogy, and this is not, because I know a lot of people do this analogy with motor vehicle collisions, but the blunt force is like what happens in a motor vehicle collision. By that, I mean deceleration. The body is traveling at 60 miles an hour and suddenly stops. I'm not equating this to that. But the blunt force is the acceleration, deceleration. The multiple is that it's repeated versus the baseball bat, a single strike. We're talking about multiple cycles of that repetitive motion that's angular. That is, it's XYZ axis, all three simultaneously.
And that's what's indicated by a retinal bleed that is too numerous to count and or that is multi-layered or that extends from the center of the retina out to the periphery. As
we understand it, that's the mechanism that's likely to cause that. There's no single diagnostic, what we call pathognomonic. That is, I see it and it has to be this, but that's where we tend to see this almost all the time.
You also made a determination in your affidavit that there were no atraumatic explanation for the condition of Kalen Garner. What do you mean by no atraumatic?
Simply, this baby's brain was devastated by something, and there's no explanation to account for that. Babies' brains don't just suddenly explode. There's something that caused Kalen's symptoms and signs, and that something is, again, multiple blunt force injuries. In the context of acceleration, deceleration. You say there was no atraumatic
explanation, but you understand from reviewing the case materials, there was an explanation given by the sole caregiver, the defendant in this case, Luther Garner, and that explanation was that he accidentally hit the child's head on the door frame.
Well, eventually, yes. I believe initially, no. That is also a sign that we see very commonly is remembered trauma. Usually when somebody comes in with a child that's obviously in a bad state, as providers, we have to believe the history that they give us, because the child's an extremist. And when we have somebody who doesn't remember trauma and then suddenly remembers minor trauma, like hitting a head on a door frame, there's a strong correlation, in my experience, of that kind of history with inflicted injuries.
And you concluded your affidavit by saying that in many cases, as in this one, retinal bleeds with severe brain swelling in the absence of subdural blood medically is confirmed.
Yes, in this case, yes.
And I think you've already addressed the next point in my outline, which is the medical findings in total, in context. And you've talked about the remembered history. Is that how you characterize it? You talked about that. And then you also mentioned the abrupt onset of massive acute brain swelling, the hypoxic ischemic encephalopathy, the nature of the retinal bleeds, and you have no reason to doubt that all of these things were presented to the jury, underlying jury in this case.
I don't have any doubt about that.
And if I represent to you that the defendant took the stand at that trial and testified on his own behalf, do you have any reason to doubt that?
None whatsoever.
Do you have any reason to doubt that this jury considered all of those things in total, even considered those things possibly as corroborating evidence? Is there any doubt in your mind that that was something?
I don't have any doubt.
And lastly, in that vein is you understand how that, at least generally speaking, how jury trials work, in that these jurors can believe some, none, or all of what a witness says, and if they chose to, they could have disregarded this defendant's testimony in its entirety.
That's my understanding.
Let me move on. I think we've done enough about.
Dr. Downs introduces a crucial distinction. Blunt force in criminal court usually means weapons like bats, but in medical forensics it includes acceleration-deceleration injuries, the whiplash effect of shaking. The prosecution's strategy becomes clear here. They're not arguing about whether shaking can cause injury. They're arguing that the specific pattern of injuries, too numerous to count retinal hemorrhages, multi-layered, extending to the periphery, matches what forensic pathologists recognize as abusive head trauma. The defense's doorframe explanation must now compete with this detailed medical narrative.
Giving the judge enough about shortfalls, but you understand
Yeah.
the theory behind it, right?
Children can get injured from shortfalls, but not the kind of injury we're talking about here. That's very unusual. I did review one paper, and there was one case that ended in a fatality, which calls that whole paper into serious question about the methodologies employed, because biomechanically, my understanding of biomechanics, I'm not a biomechanical engineer, it doesn't make any sense that that child would have sustained these massive injuries from a short fall. It's the one outlier and really calls the whole paper into question.
Very good, Dr. Downs. I think we'll leave it at that. And
That would be case number 8.
Thank you.
I think we'll leave it at that, and I'll move on. As part of your review, those files, those records included reports from other doctors, a Dr. Fernando Stein, a Dr. Patricia Moore. I just want to briefly ask you whether or not you agree with, disagree with, would like to add to, or have any concerns about their conclusions, particularly with regard to Dr. Stein and his characterization of the shaking of Kalen being both violent and of an anterior, and posterior movement, possibly multiple or repeated times, that caused the brain to shear the neutrons, to swell, and to bleed behind the eyes. Based on your review of the file in its entirety, would you agree with that, disagree with that, take issue with it, add to it?
I would modify a few things. First of all, it was neurons. I believe you said neutrons.
Oh, I'm sorry. You know, that's the
That's
second
right.
time.
That's right. He said anterior, posterior, and I agree, but I think it's more the X, Y, Z. So it's not just front and back. It's side to side, up and down, and rotating simultaneously.
Dr. Stein also characterized these movements as being fast acceleration and deceleration forces that would cause the head to move back and forth very rapidly. You agree, disagree?
I agree.
Dr. Stein also indicated that he was a pediatrician with the Texas Children's Hospital ICU unit with more than 25 years of experience. You have any reason to doubt that?
I don't.
And in your opinion, who is best suited to provide an expert opinion about shaken baby syndrome or abusive? A clinical practitioner such as Dr. Stein, or someone who is, for instance, a biomechanical engineer or a law professor?
Living or deceased patient.
That's a great distinction. I mean, as far as a deceased patient, I suspect I know what your answer will be.
I'm gonna be for the home team. I would say a forensic pathologist would be best positioned. We would obviously work with clinicians, so an ICU doc sees these kids acutely while they're alive. So certainly a valuable source of information, and absolutely somebody who is alive, I'm gonna listen to what they have to tell me. But after unfortunately passed away, then that's my.
Let's move on to the reports or information provided by Dr. Patricia Moore. She concluded that, quote, some type of direct force to the head, whether it be a shaking mechanism involved or not, there was some type of acceleration injury to cause these problems in the brain and the eyes. You agree, disagree, take issue with that?
I agree, because there has to be some way to get this devastating injury. And without anything external, acceleration, deceleration is the only mechanism to account for it.
And when asked during the trial if these injuries were consistent with a closed head trauma due to shaking, her answer was yes. You agree, disagree, based on what you reviewed in the entirety of the file?
I agree, it would be consistent with shaken baby syndrome as we termed it then.
And when asked at the trial whether or not this would have an immediate effect on the child, her answer was yes. And let me also add to this question, this whole concept of lucid intervals. If you can speak to not only whether or not you agree with her answer, but the controversy, if any, out there about lucid intervals.
So generally speaking, these injuries are devastating. It's apparent right away there's something wrong. What oftentimes happens is there's a delay in getting treatment for the child. So the child sits there and becomes more hypoxic and more ischemic. So more damage to the brain from those processes that are ongoing. Lucid interval, we are familiar with that with some types of head injuries. I can't say it doesn't happen, but it's very unusual. It would be an outlier.
You mentioned a delay in seeking treatment exacerbating the injury. Are you aware, if you recall from your review of this file, if there was a delay in seeking treatment in this case?
I believe there was.
I think that's about all on your affidavit. Let's talk about something that I suspect counsel for the applicant may want to inquire about, and that's how you are compensated. You're being paid for your expert testimony here today, correct?
I'm being paid for my time.
Yes, sir. And that's in the amount of
The prosecutor draws a sharp line between clinicians who treat living patients and forensic pathologists who examine the dead. This isn't just professional rivalry, it's about what each expert can actually see. A doctor in an ICU watches symptoms unfold. A pathologist sees tissue damage frozen in time. The jury heard both, but the prosecution wants the judge to trust the one who actually held the brain.
$500 an hour, correct?
That's correct.
Plus your expenses.
That's correct.
Is that unusual for this type of situation or expert testimony?
Not at all.
And has the payment of your hourly fee and or your expenses in any way influenced your testimony today?
No, sir, I don't testify for a side. I testify for the truth. The truth doesn't have a side. I don't care which side is asking a question. I'm going to give them the same answer.
Very good. And do you, just to shore this up, do you or a close family member have a personal interest or stake or financial stake in the outcome of this case?
No, sir, not at all.
And in fact, you've signed a disclosure, a conflict of interest disclosure form. And I think the next topic here in my outline are case studies and clinical research studies. I think I'm going to cut that down, maybe delete it altogether. The judges are.
Thank you.
You're welcome. Let me just see if there's anything in here that really lends itself to would you agree with this statement by expert witness, the Dr. John Galasnik? You're familiar with Dr. that he made on Monday. His sworn testimony was that there are hundreds of studies out there regarding shaken baby syndrome and or abusive head trauma. Would you agree with that?
That's fair. Oh, definitely.
All right, I'll just leave it at that. The judge's point. Dr. Galasnik also testified that for there to be legitimate shaken baby syndrome, there needs to be either a broken neck, a rib fracture, or some ligament damage. What are your thoughts? What's your take on it?
Well, actually, at one point in time, I would say there were a number of people in my community that felt the same way. In fact, I spent time looking at that specific question because people that thought there would be neck damage, they're really smart. So if they're right, I'm wrong. So why am I wrong? So I actually developed a technique of dissecting children's necks in shaken baby cases. And what I discovered in 100% of my cases, I found fresh blood and old blood indicating prior injury to where the spinal cord attaches inside the vertebrae. Now, other people have found lesser numbers, but in my experience, I believe that's real, and I believe it's a trauma that we don't normally see at autopsy because people don't normally do that dissection.
And part of what the judge is tasked with from the Court of Appeals is making a determination about whether or not certain science was available at the time of this particular trial. Is this what you're testifying to? Some new concept or scientific?
The concept of the spinal nerve root ganglia?
Yeah.
I started doing that, I think, in about 96. It probably didn't get published until the early 2000s, but certainly I was doing presentations on this in the 90s.
And along that vein, with regard to shaken baby syndrome in general, or abusive head trauma of infants in general, I mean, while there is this new theory of the mechanism that causes it, the science underlying that's shaken baby.
I'm sorry, a new theory of mechanism?
Yeah, the theory of mechanism meaning the shortfall or either something that mimics or maybe a rebleed, all of these things under this quote unquote new science, that may be a new.
The lucid interval theory matters enormously for the defense. If Kalen seemed fine after the alleged shaking, then collapsed later, the father might not have caused the injury or even known about it. Dr. Dans calls this very unusual and an outlier, which is expert speak for possible, but don't bet on it. The delay in treatment, he suggests, made things worse but didn't create the original damage.
Theory of the mechanism.
I wouldn't say it's a new theory of a mechanism. We've had that stuff as long as I can remember. People have said you can get this from shortfalls. There's nothing new here. This packing it up and painting it a different color doesn't change that we've thought about all this from the very beginning. I know when I was in training in the 80s and early 90s, I had cases, and I remember going through a differential that included things like falls, trauma. That's why the absence of trauma history is important. And that's really how you practice medicine. You use a diagnostic triad of history, physical, and lab testing, other testing. That is a diagnostic triad. Some people, when they're talking about shaken baby syndrome.
And I think I know where you're headed. We're going to get to that triad.
Okay.
It's part of my outline. But I think I want to circle back to something you just said about the concept of something being at least thought of or considered out there, at least in the world, in the sphere of what we're about. If that's your testimony, this is not these mechanisms are not something quote unquote new, so much as they were already around, being thought of, at least being conceptualized.
Yeah, I mean, Dr. Ambrose Tardieu in the 1800s, 1870s, 1880s, first came up with the concept of shaken baby syndrome. You'll see a lot of people attribute it to other authors in the 70s, and they did write about it, but the concepts start back in the 1800s.
But I want to be clear, I'm not talking about the concept of shaken baby syndrome or the concept of abusive head trauma. And it was a hard concept for me to wrap my brain around. there is the mechanism that leads to the diagnosis, leads to the injuries and the diagnosis of shaken baby. Now, what I'm thinking of and what my question is, has that mechanism, the mechanism being either shortfall or some ailment that mimics shaken baby, or either any of those things. Is it fair to say that that's been advanced here recently, or quote unquote new?
Some people have said it's new. I think the only serious disagreement or question is whether it requires an impact or not. Certainly it's much easier to damage a brain with an impact. I don't think anybody will dispute that. The question is, can shaking alone cause these injuries? And most of the cases have an impact, so it's really not hard.
Biomechanical modeling, this judge has heard quite a bit about that. I'm not going to spend much time on it. In your affidavit, you saw fit to characterize relying on biomechanical modeling as malpractice.
I think there was more to the sentence than that.
Please elaborate.
To the exclusion of reality. That is, modeling is great. It's a tool. It's a wonderful, powerful tool, but it should not supplant reality. If there's some issue between agreement of reality and the model's flawed. So we're getting there. We don't have perfect models. They have to make assumptions. They have to do things like scale, which is take a low force on a little model and make that bigger because a human being is bigger than a rat. And they have to do things like switch from considering rat brains to considering human infant brains. So there's some assumptions that are made that are important to understand the whole process.
I mean, things like the details matter. Things like the strength of the neck muscles of an infant. I mean, that needs to be quantified. It needs to be taken into.
I mean, take that. That's a really good example. It's not only the strength of a child's neck muscles compared to a lamb's neck muscles. You anesthetize the lamb. So they don't have the sympathetic parasympathetic nervous system that's going to stimulate the body. You have basically put them to sleep. Well, in a human being, in the real world, you haven't done that. And that's an important remember that the research may constrain or limit how the head moves. That's not reality. So all of those things are critically important when you're reading papers. There's great research out there, but we aren't there yet.
And I want to keep circling back to what was available, at least in thought, or at least in the common consciousness back in the early 2000s. And I want to make sure that because again, that's part of what the judge is tasked with, determining whether or not there's quote unquote new science out there. At least what you just testified to about whether or not it's an apples to apples comparison with biomodeling technology or science, a concept in the early 2000s.
I really couldn't tell you. I'm not a biomechanical engineer. Certainly we had thoughts about doing models, but the modeling then was much more primitive than it is now. So I can't speak directly to it because that's outside of my field. I don't know exactly where they were.
I think you have answered my question. If it was more primitive than it is now, wouldn't it be a fair assessment that it would have been more unreliable than it is now?
Back in the day, I think as a generalization, that's probably true because we didn't have the detail and the understanding that we do now. But again, I'm not a biomechanical engineer, so I'm not going to pretend that I know that field.
Fair enough. Dr. Glasnick on Monday also theorized that a plausible alternative in this particular case was an epidural hematoma, the primary injury, that led to the secondary injury of an intracranial venous thrombosis, a clot that eventually was what caused the injury to fatal injury to Kalen Garner in this case. And all of that came from the minor trauma of hitting the father accidentally. What are your thoughts on that?
An epidural?
I said epidural. Am I incorrect in that?
I would think that maybe subdural.
Oh, no. He specifically said epidural hematoma.
I don't really see that follows epidural. The skull is like a bony sphere, like an eggshell. And you know the membrane inside an eggshell? Think of that like the dura mater. Epidural would be between that membrane and the skull surface. Subdural is between the membrane and the white of the egg. And that could be associated, but when you have a venous sinus thrombosis, there's something that causes that. So to posit that mechanism you just gave me, if we say that epidural or subdural, is getting it backwards. You've got the result as the cause. When you stop the blood flow into the brain, of course, the blood clots in the venous sinus. That's what it does. To get a primary venous sinus thrombosis, you need things like a serious infection, you need dehydration. It doesn't just spontaneously happen.
Have you ever seen an epidural hematoma on a CAT scan, CT scan?
I have seen epidurals and subdurals for that matter.
Who's most qualified to make a determination from a CAT scan with regard to that epidural hematoma? Let me just ask you this: neuroradiologist.
Absolutely.
Now let's talk about the triad. What you've done is, I heard you distinctly refer to triad as opposed to just a triad. Why do you make that distinction?
Well, it's important because it's foundational. It's all of
Dr. Dans just exposed a critical flaw in how courts evaluate scientific evidence: the gap between laboratory models and real-world injury. Michigan courts follow the Daubert standard for expert testimony, which requires methods to be reliable and relevant. When a doctor admits biomechanical modeling should not supplant reality, he's highlighting why judges must scrutinize whether studies actually replicate human conditions or just approximate them.
medicine. All doctors do the same thing. You go to the doctor, first thing, why are you here? That's history. Then the doc will look at you. That's physical. Then lab testing. We're going to do some blood work, we're going to do some x-rays, CT, whatever it is. We use those methodologies day to day, every day in medicine. So that's how we diagnose things. If you think about what I've heard some in the doubter community, that shaken baby is a thing, will say that subdural hemorrhage, retinal hemorrhage, and brain swelling, cerebral edema, that's a diagnostic triad. Those are three physical findings. That's only 1/3 of the actual way you diagnose something. So it's disingenuous in my book to try to present three physical findings in isolation and to say that medical practitioners diagnose shaken baby syndrome based on those three findings in isolation. And I further say, and have said for many years, it would be medical malpractice if someone were to diagnose based on those three findings in isolation. And I honestly don't believe any responsible practitioner this year, last year, 20 years ago, 50 years ago, ever diagnosed anything based on those any three physical findings in isolation.
I think that's just about all I have for you, Dr. Down. I guess a couple of wraps up. You indicate in your affidavit that, quote, over a dozen multinational professional medical societies have confirmed the validity of the diagnosis of shaken baby syndrome or abuse. Characterization of what you put. And my final question to you is, based on your training experience and your medical knowledge, is the theory behind the diagnosis of shaken baby syndrome or abusive head trauma, does that still remain generally accepted? Let me ask, not only the theory, but the science. Does the science remain generally accepted by the physicians who frequently encounter?
Absolutely. The people that would see more of these patients than anyone else would be pediatricians, because most of the cases are not lethal. Only a minority, fortunately, come to my attention. But not only the pediatric community, but the forensic pathology community, and I think medicine everywhere. It's in the ICD, the International Diagnostic Code book, has a code for abusive head trauma. That means that, not to get mercenary, but people are reimbursing for care for this diagnosis.
Mr. Yudishin.
Dr. Dance, my name is Gary Yudishin, and I don't think we've met.
Pleasure to meet you, sir.
Thank you. And I'm one of Mr. Garner's attorneys. Let me start with where you ended. There does seem to be material out in the world that says that the pediatricians, particularly the child abuse pediatricians, support the general idea of abusive head trauma.
Well, you mentioned the subpopulation of pediatricians. I would say most pediatricians, probably not all, but I would say most all.
And I mean, isn't it true that nobody really says there's no such thing as abusive head trauma? I mean, that's not a contentious issue, is it?
I have seen people that will come up with some ingenious possibilities to discount abusive head trauma.
But you said earlier that the only real issue in this area is whether you need an impact or whether shaking alone will do it.
I believe that's true, yes.
And when you say that's the only real issue, that is the issue in the entire medical and biomechanical communities, that's the thing that's contentious.
Well, I think from my perspective, at least, I would agree with that. I can't speak for everybody. I can only speak for myself.
And you did mention that you had testified in the Robert Roberson trial.
That's correct.
And so welcome back to Texas.
I get here frequently, sir. Good to be back.
All right. So in the Robert Roberson trial, I think you said something like that's the only real issue, at least the only real issue that in your view, the only legitimate issue is, do you need an impact or is shaking alone enough to cause these conditions?
Correct. And I think, again, everyone would agree generally that it's much easier to injure somebody with an impact.
And do you recall in the Robert Roberson case, saying when you were explaining to the judge there that really is the only issue? So the issue is, do you need an impact or is shaking alone enough? And you saying, and you're just not positive one way or the other about that personally.
Personally, I am not certain. I have seen studies that cut both ways on the question.
And so you look at the science.
I try to look at the best science that's available. And the key there is best science because a lot of stuff gets published. I spent last night looking at quite a few papers.
Okay, so if you are not certain whether shaking alone is enough to...
The defense just scored a crucial admission. The state's own expert won't say shaking alone definitely caused these injuries. Dr. Danz's uncertainty, I am not certain, directly contradicts Dr. Stein's trial testimony that absolutely shaking caused this, nothing else. In post-conviction proceedings, this kind of changed scientific understanding can be grounds for relief if the original conviction rested on now discredited certainty.
Pretty quickly are getting into now that I've heard several. So I'm not going to, I don't want you to take it personal if I say, okay, I'm good, let's move on, is I guess. So try to do what you want to do. If I feel like it's helping me in my decision, I'm going to let you go. I might just kind of slow it down, stop it, redirect a little bit more than I have been so we can get through it. All right.
That sounds good.
Okay, perfect. Mr. Coleman, you may call your next witness.
State called Dr. James Downs. He has this one.
Thank you. Good morning, sir.
Good morning, ma'am.
Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? And Dr. Downs, you can thank me later for what I just told the attorneys.
Thank you in advance, too.
Mr. Coleman, you may proceed.
Thank you, Your Honor. Good morning, Dr. Downs.
Good morning, sir.
Would you please state your full name for the court reporter?
James Claude Upshaw Downs, MD.
But you also go by Jamie, correct?
Correct.
Jamie.
That's correct.
Dr. Downs, you're back. Well, what do you do for a living, please, sir?
I'm a forensic pathologist, medical legal consultant. I also am the medical director for the physician assistant program at Charleston Southern University.
Are you board certified as a forensic pathologist?
I'm board certified in anatomic, clinical, and forensic pathology.
More than 33 years of experience in that area?
Actually, I tallied it up, it's 35.
All right. And are you also certified by the National Board of Medical Examiners and American Board of Pathology?
The National Association of Medical Examiners, I'm a fellow of that organization. I'm board certified by the American Board of Pathology.
How many states are you licensed to practice medicine in, sir?
Georgia, South Carolina, Alabama.
Have you been the chief medical examiner of the state of Alabama?
Yes, sir.
And director of the, please tell the judge about your involvement in the Shaken Baby Alliance, if you don't mind, sir.
So I am a consultant with them. I regularly do trainings for that organization. And I've known the executive director, probably 25 years.
And it goes without saying that you, over the course of your career, you testified in court before?
Yes, sir. Many times, as recently as last night.
Yeah. In fact, you're in the middle of a trial in California, correct?
Sir, they just released me
All right,
at 7 p.m. your time last night.
very good.
We appreciate you getting here.
So
And,
do I.
and testified on,
Many occasions. I've been given sworn testimony in probably 20 states, also federal courts, military hearings, given sworn testimony before subcommittees of the U.S. House, U.S. Senate, as well as before the National Commission on Forensic Sciences.
and lastly, you've provided expert testimony in the Robert Roberson case out of Anderson County, Texas, correct?
That's correct.
That deals with the post-conviction writ involving a shaken baby case as well, right?
That's correct.
You've had an opportunity pursuant to the request of the district attorney's office to review a case file related to a deceased. Those records, if you recall, what did they include?
Transcripts, medical records, autopsy records, scene photographs, autopsy photographs.
And after reviewing those records, did you prepare an affidavit summarizing your conclusion or conclusions?
I did.
And by way of summary, if we could walk through that affidavit for a determination that there was an abrupt onset of physical signs and symptoms of massive acute brain swelling and unresponsiveness, along with pathologic,
Yes, in a very young child.
a 2-month-old, in fact.
Yes, sir.
Could you unpack that for the judge? Massive acute brain swelling.
The brain got fluid on it and got too large to function normally inside the skull, puts pressure on the brainstem and shuts down vital systems.
Unresponsive and pathologic posturing.
The neural pathways are impacted, so their positions of the body, decorticate and decerebrate. That's what posturing means. It's just how your hands are positioned.
Based on your review of the file or the records, you also determined there was hypoxic ischemic encephalopathy. That's essentially oxygen deprivation and or limited blood flow, correct?
Hypoxia is low oxygen, ischemia is no blood flow.
And you also made a determination that there were retinal bleeds. How would you characterize those retinal bleeds?
Too numerous to count.
And the judges heard testimony about numerosity of retinal bleeds and it being multi-layered. In your training and experience, what are those things indicative of?
Well, they're not seen very commonly. The only place that we commonly see that would be in cases like this of what was formerly called shaken baby syndrome, now called abusive head trauma. In my world, multiple blunt force injuries. The blunt force would be an acceleration, deceleration.
And I want to spend just a little bit of time on the injuries, because to characterize that as blunt force injuries in the context in the world that we deal with in the criminal court realm, when we hear the term blunt forces, we think of like infliction of an injury by like a baseball bat or something that you're using as like a club or something to hit. You're talking about blunt forces in the context of acceleration and deceleration. Please elaborate on that.
Sure. So I'll give you an analogy, and this is not because I know a lot of people do this analogy with motor vehicle collisions, but the blunt force is like what happens in a motor vehicle collision. By that, I mean deceleration. The body is traveling at 60 miles an hour and suddenly stops. I'm not equating this to that. But the blunt force is the acceleration, deceleration. The multiple is that it's repeated versus the baseball bat, a single strike. We're talking about multiple cycles of that repetitive motion that's angular. That is, it's XYZ axis, all three simultaneously.
And that's what's indicated by a retinal bleed that is too numerous to count and or that is multi-layered or that extends from the center of the retina out to the periphery. As
we understand it, that's the mechanism that's likely to cause that. There's no single diagnostic, what we call pathognomonic. That is, I see it and it has to be this, but that's where we tend to see this almost all the time.
You also made a determination in your affidavit that there were no atraumatic explanation for the condition of Kalen Garner. What do you mean by no atraumatic?
Simply, this baby's brain was devastated by something, and there's no explanation to account for that. babies' brains don't just suddenly explode. There's something that caused Kalen's symptoms and signs. And that something is, again, multiple blunt force injuries.
In the context of acceleration, deceleration. And you say there was no atraumatic explanation, but you understand from reviewing the case materials, there was an explanation given by the sole caregiver, the defendant in this case, Luther Garner, and that explanation was that he accidentally hit the child's head on the door frame.
Well, eventually, yes. I believe initially, no. That is also a sign that we see very commonly is remembered trauma. Usually when somebody comes in with a child that's obviously in a bad state, as providers, we have to believe the history that they give us, because the child's an extremist. And when we have somebody who doesn't remember trauma and then suddenly remembers minor trauma, like hitting a head on a door frame, there's a strong correlation, in my experience, of that kind of history with inflicted injuries.
And you concluded your affidavit by saying that in many cases, as in this one, retinal bleeds with severe brain swelling in the absence of subdural blood medically is confirmed.
Yes, in this case, yes.
All right. And I think you've already addressed the next point in my outline, which is the medical findings in total, in context. And you've talked about the remembered history. Is that how you characterize it? You talked about that. And then you also mentioned the abrupt onset of massive acute brain swelling, the hypoxic ischemic encephalopathy, the nature of the retinal bleeds, and you have no reason to doubt that all of these things were presented to the jury, underlying jury in this case.
I don't have any doubt about that.
And if I represent to you that the defendant took the stand at that trial and testified on his own behalf, do you have any reason to doubt that?
None whatsoever.
Do you have any reason to doubt that this jury considered all of those things in total, even consider those things possibly as corroborating evidence? Is there any doubt in your mind that that was something?
I don't
possible?
have any doubt.
And lastly, in that vein is you understand how that, at least generally speaking, how jury trials work, in that these jurors can believe some, none, or all of what a witness says, and if they chose to, they could have disregarded this defendant's testimony in its entirety.
That's my understanding.
Let me move on. I think we've done enough about, or given the judge enough about shortfalls, but you understand
Yeah.
the theory behind it, right?
Children can get injured from shortfalls, but not the kind of injury we're talking about here. That's very unusual. I did review one paper, and there was one case that ended in a fatality, which calls that whole paper into serious question about the methodologies employed, because biomechanically, my understanding of biomechanics, I'm not a biomechanical engineer, it doesn't make any sense that that child would have sustained these massive injuries from a short fall. It's the one outlier and really calls the whole paper into question.
Very good, Dr. Downs. I think we'll leave it at that. And
That would be case number 8.
Thank you.
I think we'll leave it at that, and I'll move on. As part of your review, those files, those records included reports from other doctors, a Dr. Fernando Stein, a Dr. Patricia Moore. I just want to briefly ask you whether or not you agree with, disagree with, would like to add to, or have any concern about their conclusions, particularly with regard to Dr. Stein and his characterization of the shaking of Kalen being both violent and of an anterior, and posterior movement, possibly multiple or repeated times, that caused the brain to shear the neutrons, to swell, and to bleed behind the eyes. Based on your review of the file in its entirety, would you agree with that, disagree with that, take issue with it, add to it?
I would modify a few things. First of all, it was neurons. I believe you said neutrons.
Oh, I'm sorry. You know, it's the
That's
second
right.
time.
That's right. He said anterior, posterior, and I agree, but I think it's more the X, Y, Z. So it's not just front and back. It's side to side, up and down, and rotating simultaneously.
Dr. Stein also characterized these movements as being fast acceleration and deceleration forces that would cause the head to move back and forth very rapidly. You agree, disagree?
I agree.
Dr. Stein also was indicated that he was a pediatrician with the Texas Children's Hospital ICU unit with more than 25 years of experience. You have any reason to doubt that?
I don't.
And in your opinion, who is best suited to provide an expert opinion about shaken baby syndrome or abusive? A clinical practitioner such as Dr. Stein, or someone who is for instance, a biomechanical engineer or a law professor?
Living or deceased patient.
That's a great distinction. I mean, as far as a deceased patient, I suspect I know what your answer will be.
I'm gonna be for the home team. I would say a forensic pathologist would be best positioned. We would obviously work with clinicians, so an ICU doc sees these kids acutely while they're alive. So certainly a valuable source of information, and absolutely somebody who is alive, I'm gonna listen to what they have to tell me. But after unfortunately passed away, then that's my.
Let's move on to the reports or information provided by Dr. Patricia Moore. She concluded that, quote, some type of direct force to the head, whether it be a shaking mechanism involved or not, there was some type of acceleration injury to cause these problems in the brain and the eyes. You agree, disagree, take issue with that?
I agree, because there has to be some way to get this devastating injury. And without anything external, acceleration, deceleration is the only mechanism to account for it.
And when asked during the trial if these injuries were consistent with a closed head trauma due to shaking, her answer was yes. You agree, disagree, based on what you reviewed in the entirety of the file?
I agree, it would be consistent with shaken baby syndrome as we termed it then.
And when asked at the trial whether or not this would have an immediate effect on the child, her answer was yes. And let me also add to this question, this whole concept of lucid intervals. If you can speak to not only whether or not you agree with her answer, but the controversy, if any, out there about lucid intervals.
So generally speaking, these injuries are devastating. It's apparent right away there's something wrong. What oftentimes happens is there's a delay in getting treatment for the child. So the child sits there and becomes more hypoxic and more ischemic. So more damage to the brain from those processes that are ongoing. Lucid interval, we are familiar with that with some types of head injuries. I can't say it doesn't happen, but it's very unusual. It would be an outlier.
You mentioned a delay in seeking treatment exacerbating the injury. Are you aware, if you recall from your review of this file, if there was a delay in seeking treatment in this case?
I believe there was.
I think that's about all on your affidavit. Let's talk about something that I suspect counsel for the applicant may want to inquire about, and that's how you are compensated. You're being paid for your expert testimony here today, correct?
I'm being paid for my time.
Yes, sir. And that's in the amount of $500 an hour, correct?
That's correct.
Plus your expenses.
That's correct.
Is that unusual for this type of situation or expert testimony?
Not at all.
And has the payment of your hourly fee and or your expenses in any way influenced your testimony today?
No, sir, I don't testify for a side. I testify for the truth. The truth doesn't have a side. I don't care which side is asking a question. I'm going to give them the same answer.
Very good. And do you, just to shore this up, do you or a close family member have a personal interest or stake or financial stake in the outcome of this case?
No, sir, not at all.
And in fact, you've signed a disclosure, a conflict of interest disclosure form. And I think the next topic here in my outline are case studies and clinical research studies. I think I'm going to cut that down, maybe delete it altogether. The judges here.
Thank you.
You're welcome. Let me just see if there's anything in here that really lends itself to your. Would you agree with this statement by expert witness, Dr. John Galasnik? You're familiar with Dr. that he made on Monday. His sworn testimony was that there are hundreds of studies out there regarding shaken baby syndrome and or abusive head trauma. Would you agree with that?
That's fair. Oh, definitely.
All right, I'll just leave it at that. The judges are. Dr. Galasnik also testified that for there to be legitimate shaken baby syndrome, there needs to be either a broken neck, a rib fracture, or some ligament damage. What are your thoughts? What's your take on it?
Well, actually, at one point in time, I would say there were a number of people in my community that felt the same way. In fact, I spent time looking at that specific question because people that thought there would be neck damage, they're really smart. So if they're right, I'm wrong. So why am I wrong? So I actually developed a technique of dissecting children's necks in shaken baby cases. And what I discovered in 100% of my cases, I found fresh blood and old blood indicating prior injury to where the spinal cord attaches inside the vertebrae. Now, other people have found lesser numbers, but in my experience, I believe that's real, and I believe it's a trauma that we don't normally see at autopsy because people don't normally do that dissection.
And part of what the judge is tasked with from the Court of Criminal Appeals is making a determination about whether or not certain science was available at the time of this particular trial. Is this what you're testifying to, some new concept or scientific?
The concept of the spinal nerve root ganglia.
Yeah.
I started doing that, I think, in about 96. It probably didn't get published until